This audio case is brought to you by Laudio. Michigan v. Long. Decided July 6, 1983. O'Connor delivered the opinion of the court. In Terry v. Ohio, we upheld the validity of a protective search for weapons in the absence of probable cause to arrest, because it is unreasonable to deny a police officer the right to neutralize the threat of physical harm when he possesses an articulable suspicion that an individual is armed and dangerous. We did not, however, expressly address whether such a protective search for weapons could extend to an area beyond the person in the absence of probable cause to arrest. In the present case, Respondent David Long was convicted for possession of marijuana found by police in the passenger compartment and trunk of the automobile that he was driving. The police searched the passenger compartment because they had reason to believe that the vehicle contained weapons potentially dangerous to the officers. We hold that the protective search of the passenger compartment was reasonable under the principles articulated in Terry and other decisions of this court. We also examined Long's argument that the decision below rests upon an adequate and independent state ground, and we decide in favor of our jurisdiction. Deputies Howell and Lewis were on patrol in a rural area one evening when, shortly after midnight, they observed a car traveling erratically and at excessive speed. The officers observed the car turning down a side road, where it swerved off into a shallow ditch. The officers stopped to investigate. Long, the only occupant of the automobile, met the deputies at the rear of the car, which was protruding from the ditch onto the road. The door on the driver's side of the vehicle was left open. Deputy Howell requested Long to produce his operator's license, but he did not respond. After the request was repeated, Long produced his license. Long again failed to respond when Howell requested him to produce the vehicle registration. After another repeated request, Long, who Howell thought appeared to be under the influence of something, turned from the officers and began walking toward the open door of the vehicle. The officers followed Long, and both observed a large hunting knife on the floorboard of the driver's side of the car. The officers then stopped Long's progress and subjected him to a Terry protective pat-down, which revealed no weapons. Long and Deputy Lewis then stood by the rear of the vehicle while Deputy Howell shined his flashlight into the interior of the vehicle, but did not actually enter it. The purpose of Howell's action was to search for other weapons. The officer noticed that something was protruding from under the armrest on the front seat. He knelt in the vehicle and lifted the armrest. He saw an open pouch on the front seat, and upon flashing his light on the pouch, determined that it contained what appeared to be marijuana. After Deputy Howell showed the pouch and its contents to Deputy Lewis, Long was arrested for possession of marijuana. A further search of the interior of the vehicle, including the glove box, revealed neither more contraband nor the vehicle registration. The officers decided to impound the vehicle. Deputy Howell opened the trunk, which did not have a lock, and discovered inside it approximately 75 pounds of marijuana. The Barry County Circuit Court denied Long's motion to suppress the marijuana taken from both the interior of the car and its trunk. He was subsequently convicted of possession of marijuana. The Michigan Court of Appeals affirmed Long's conviction, holding that the search of the passenger compartment was valid as a protective search under Terry, and that the search of the trunk was valid as an inventory search under South Dakota v. Opperman. The Michigan Supreme Court reversed. The court held that the sole jurisdiction of the Terry search, protection of the police officers and others nearby, cannot justify the search in this case. The marijuana found in Long's trunk was considered by the court below to be the fruit of the illegal search of the interior, and was also suppressed. We granted certiorari in this case to consider the important question of the authority of a police officer to protect himself by conducting a Terry-type search of the passenger compartment of a motor vehicle during a lawful investigatory stop of the occupant of the vehicle. Before reaching the merits, we must consider Long's argument that we are without jurisdiction to decide this case because the decision below rests on an adequate and independent state ground. The court below referred twice to the state constitution in its opinion, but otherwise relied exclusively on federal law. Long argues that the Michigan courts have provided greater protection from searches and seizures under the state constitution than is afforded under the Fourth Amendment, and the references to the state constitution therefore establish an adequate and independent ground for the decision below. It is, of course, incumbent upon this court to ascertain for itself whether the asserted non-federal ground independently and adequately supports the judgment. Although we have announced a number of principles in order to help us determine whether various forms of references to state law constitute adequate and independent state grounds, we openly admit that we have thus far not developed a satisfying and consistent approach for resolving this vexing issue. In some instances, we have taken the strict view that if the ground of decision was at all unclear, we would dismiss the case. In other instances, we have vacated or continued a case in order to obtain clarification about the nature of a state court decision. In more recent cases, we have ourselves examined state law to determine whether state courts have used federal law to guide their application of state law or to provide the actual basis for the decision that was reached. In Oregon v. Kennedy, we rejected an invitation to remand to the state court for clarification, even when the decision rested in part on a case from the state court, because we determined that the state case itself rested upon federal grounds. We added that even if the case admitted of more doubt as to whether federal and state grounds for decision were intermixed, the fact that the state court relied to the extent it did on federal grounds requires us to reach the merits. This ad hoc method of dealing with cases that involve possible adequate and independent state grounds is antithetical to the doctrinal consistency that is required when sensitive issues of federal-state relations are involved. Moreover, none of the various methods of disposition that we have employed thus far recommends itself as the preferred method that we should apply to the exclusion of others, and we therefore determine that it is appropriate to re-examine our treatment of this jurisdictional issue in order to achieve the consistency that is necessary. The process of examining state law is unsatisfactory because it requires us to interpret state laws with which we are generally unfamiliar and which often, as in this case, have not been discussed at length by the parties. Vacation and continuance for clarification have also been unsatisfactory, both because of the delay and decrease in efficiency of the judicial administration and, more important, because these methods of disposition place significant burdens on state courts to demonstrate the presence or absence of our jurisdiction. Finally, outright dismissal of cases is clearly not a panacea because it cannot be doubted that there is an important need for uniformity in federal law, and that this need goes unsatisfied when we fail to review an opinion that rests primarily upon federal grounds and where the independence of an alleged state ground is not apparent from the four corners of the opinion. We have long recognized that dismissal is inappropriate where there is strong indication that the federal Constitution, as judicially construed, controlled the decision below. Respect for the independence of state courts, as well as avoidance of rendering advisory opinions, have been the cornerstones of this court's refusal to decide cases where there is an adequate and independent state ground. It is precisely because of this respect for state courts and this desire to avoid advisory opinions that we do not wish to continue to decide issues of state law that go beyond the opinion that we review, or to require state courts to reconsider cases to clarify the grounds of their decisions. Accordingly, when, as in this case, a state court decision fairly appears to rest primarily on federal law or to be interwoven with the federal law, and when the adequacy and independence of any possible state law ground is not clear from the face of the opinion, we will accept as the most reasonable explanation that the state court decided the case the way it did because it believed that federal law required it to do so. If a state court chooses merely to rely on federal precedents, as it would on the precedents of all other jurisdictions, then it need only make clear by a plain statement in its judgment or opinion that the federal cases are being used only for the purpose of guidance, and do not themselves compel the result that the court has reached. In this way, both justice and judicial administration will be greatly improved. If the state court decision indicates clearly and expressly that it is alternatively based on bona fide, separate, adequate, and independent grounds, we, of course, will not undertake to review the decision. This approach obviates, in most instances, the need to examine state law in order to decide the nature of the state court decision, and will, at the same time, avoid the danger of our rendering advisory opinions. It also avoids the unsatisfactory and intrusive practice of requiring state courts to clarify their decisions to the satisfaction of this court. We believe that such an approach will provide state judges with a clearer opportunity to develop state jurisprudence, unimpeded by federal interference, and yet will preserve the integrity of federal law. It is fundamental that state courts be left free and unfettered by us in interpreting their state constitutions. But it is equally important that ambiguous or obscure adjudications by state courts do not stand as barriers to a determination by this court of the validity under the federal constitution of state action. The principle that we will not review judgments of state courts that rest on adequate and independent state grounds is based, in part, on the limitations of our own jurisdiction. The jurisdictional concern is that we not render an advisory opinion, and if the same judgment would be rendered by the state court after we corrected its views of federal laws, our review could amount to nothing more than an advisory opinion. Our requirement of a plain settlement that a decision rests upon adequate and independent state grounds does not in any way authorize the rendering of advisory opinions. Rather, in determining, as we must, whether we have jurisdiction to review a case that is alleged to rest on adequate and independent state grounds, we merely assume that there are no such grounds when it is not clear from the opinion itself that the state court relied upon an adequate and independent state ground, and when it fairly appears that the state court rested its decision primarily on federal law. Our review of the decision below under this framework leaves us unconvinced that it rests upon an independent state ground. Apart from its two citations to the state constitution, the court below relied exclusively on its understanding of Terry and other federal cases. Not a single state case was cited to support the state court's holding that the search of the passenger compartment was unconstitutional. Indeed, the court declared that the search in this case was unconstitutional because the Court of Appeals erroneously applied the principles of Terry v. Ohio to the search of the interior of the vehicle in this case. The references to the state constitution in no way indicate that the decision below rested on grounds in any way independent from the state court's interpretation of federal law. Even if we accept that the Michigan Constitution has been interpreted to provide independent protection for certain rights also secured under the Fourth Amendment, it fairly appears in this case that the Michigan Supreme Court rested its decision primarily on federal law. Rather than dismissing the case or requiring that the state court reconsider its decision on our behalf solely because of a mere possibility that an adequate and independent ground supports the judgment, we find that we have jurisdiction in the absence of a plain statement that the decision below rested on an adequate and independent state ground. It appears to us that the state court felt compelled by what it understood to be federal constitutional considerations to construe its own law in the manner that it did. The court below held, and respondent long contends, that Deputy Howell's entry into the vehicle cannot be justified under the principles set forth in Terry because Terry authorized only a limited pat-down search of a person suspected of criminal activity, rather than a search of an area. Although Terry did involve the protective frisk of a person, we believe that the police action in this case is justified by the principles that we have already established in Terry and other cases. In Terry, the court examined the validity of a stop and frisk in the absence of probable cause and a warrant. The police officer in Terry detained several suspects to ascertain their identities, and the officer had observed the suspects for a brief period of time and formed the conclusion that they were about to engage in criminal activity. Because the officer feared that the suspects were armed, he patted down the outside of the suspects' clothing and discovered 2 revolvers. Examining the reasonableness of the officer's conduct in Terry, we held that there is no ready test for determining reasonableness other than by balancing the need to search or seize against the invasion which the search or seizure entails. Although the conduct of the officer in Terry involved a severe though brief intrusion upon cherished personal security, we found that the conduct was reasonable when we weighed the interest of the individual against the legitimate interest in crime prevention and detection and the need for law enforcement officers to protect themselves and other prospective victims of violence in situations where they may lack probable cause for an arrest. When the officer has a reasonable belief that the individual whose suspicious behavior he is investigating at close range is armed and presently dangerous to the officer or to others, it would appear to be clearly unreasonable to deny the officer the power to take necessary measures to determine whether the person is in fact carrying a weapon and to neutralize the threat of physical harm. Although Terry itself involved the stop and subsequent pat-down search of a person, we were careful to note that we need not develop at length in this case. However, the limitations which the Fourth Amendment places upon a protective search and seizure for weapons. These limitations will have to be developed in the concrete, factual circumstances of individual cases. Contrary to Long's view, Terry need not be read as restricting the preventative search to the person of the detained suspect. In two cases in which we applied Terry to specific factual situations, we recognized that investigative detentions involving suspects in vehicles were especially fraught with danger to police officers. In Pennsylvania v. Mims, we held that police may order persons out of an automobile during a stop for a traffic violation and may frisk those persons for weapons if there is a reasonable belief that they are armed and dangerous. Our decision rested in part on the inordinate risk confronting an officer as he approaches a person seated in an automobile. In Adams v. Williams, we held that the police, acting on an informant's tip, may reach into the passenger compartment of an automobile to remove a gun from a driver's waistband, even where the gun was not apparent to the officer from outside the car and the officer knew of its existence only because of the tip. Again, our decision rested in part on our view of the danger presented to police officers in traffic stop and automobile situations. Finally, we have also expressly recognized that suspects may injure police officers and others by virtue of their access to weapons, even though they may not themselves be armed. In the term following Terry, we decided Chimmel v. California, which involved the limitations imposed on police authority to conduct a search incident to a valid arrest. Relying explicitly on Terry, we held that when an arrest is made, it is reasonable for the arresting officer to search the arrestee's person and the area within his immediate control, construing that phrase to mean the area from within which he might gain possession of a weapon or destructible evidence. We reasoned that a gun on a table or in a drawer in front of one who is arrested can be as dangerous to the arresting officer as one concealed in the clothing of the person arrested. In New York v. Belton, we determined that the lower courts have found no workable definition of the area within the immediate control of the arrestee when that area arguably includes the interior of an automobile and the arrestee is its recent occupant. In order to provide a workable rule, we held that articles inside the relatively narrow compass of the passenger compartment of an automobile are in fact generally, even if not inevitably, within the area into which an arrestee might reach in order to grab a weapon. We also held that the police officer may examine the contents of any open or closed container found within the passenger compartment, for if the passenger compartment is within the reach of the arrestee, so will containers in it be within his reach. Our past cases indicate, then, that protection of police and others can justify protective searches when police have a reasonable belief that the suspect poses a danger, that roadside encounters between police and suspects are especially hazardous, and that danger may arise from the possible presence of weapons in the area surrounding a suspect. These principles compel our conclusion that the search of the passenger compartment of an automobile, limited to those areas in which a weapon may be placed or hidden, is permissible if the police officer possesses a reasonable belief based on specific and articulable facts, which taken together with the rational inferences from those facts, reasonably warrant the officer in believing that the suspect is dangerous, and the suspect may gain immediate control of weapons. The issue is whether a reasonably prudent man, in the circumstances, would be warranted in the belief that his safety or that of others was in danger. If a suspect is dangerous, he is no less dangerous simply because he is not arrested. If, while conducting a legitimate Terry search of the interior of the automobile, the officer should, as here, discover contraband other than weapons, he clearly cannot be required to ignore the contraband, and the Fourth Amendment does not require its suppression in such circumstances. The circumstances of this case clearly justified Deputies Howell and Lewis in their reasonable belief that Long posed a danger if he were permitted to re-enter his vehicle. The hour was late and the area rural. Long was driving his automobile at excessive speed, and his car swerved into a ditch. The officers had to repeat their questions to Long, who appeared to be under the influence of some intoxicant. Long was not frisked until the officers observed that there was a large knife in the interior of the car into which Long was about to re-enter. The subsequent search of the car was restricted to those areas to which Long would generally have immediate control and that could contain a weapon. The trial court determined that the leather pouch containing marijuana could have contained a weapon. It is clear that the intrusion was strictly circumscribed by the exigencies which justified its initiation. In evaluating the validity of an officer's investigative or protective conduct under Terry, the touchstone of our analysis is always the reasonableness in all the circumstances of the particular governmental invasion of a citizen's personal security. In this case, the officers did not act unreasonably in taking preventative measures to ensure that there were no other weapons within Long's immediate grasp before permitting him to re-enter his automobile. Therefore, the balancing required by Terry clearly weighs in favor of allowing the police to conduct an area search of the passenger compartment to uncover weapons, as long as they possess an articulable and objectively reasonable belief that the suspect is potentially dangerous. The Michigan Supreme Court appeared to believe that it was not reasonable for the officers to fear that Long could injure them, because he was effectively under their control during the investigative stop and could not get access to any weapons that might have been located in the automobile. This reasoning is mistaken in several respects. During any investigative detention, the suspect is in the control of the officers in the sense that he may be briefly detained against his will. Just as a Terry suspect on the street may, despite being under the brief control of a police officer, reach into his clothing and retrieve a weapon, so might a Terry suspect in Long's position break away from police control and retrieve a weapon from his automobile. In addition, if the suspect is not placed under arrest, he will be permitted to re-enter his automobile, and he will then have access to any weapons inside. Or, as here, the suspect may be permitted to re-enter the vehicle before the Terry investigation is over, and again may have access to weapons. In any event, we stress that a Terry investigation, such as the one that occurred here, involves a police investigation at close range when the officer remains particularly vulnerable, in part because a full custodial arrest has not been effected, and the officer must make a quick decision as to how to protect himself and others from possible danger. In such circumstances, we have not required that officers adopt alternative means to ensure their safety in order to avoid the intrusion involved in a Terry encounter. The trial court and the Court of Appeals upheld the search of the trunk as a valid inventory search under this court's decision in South Dakota v. Opperman. The Michigan Supreme Court did not address this holding, and instead suppressed the marijuana taken from the trunk as a fruit of the illegal search of the interior of the automobile. Our holding that the initial search was justified under Terry makes it necessary to determine whether the trunk search was permissible under the Fourth Amendment. However, we declined to address this question because it was not passed upon by the Michigan Supreme Court, whose decision we review in this case. We remand this issue to the court below to enable it to determine whether the trunk search was permissible under or other decisions of this court. The judgment of the Michigan Supreme Court is reversed, and the case is remanded for further proceedings not inconsistent with this opinion. Justice Blackmun, concurring in part and concurring in the judgment. I join parts 1, 3, 4, and 5 of the court's opinion. While I am satisfied that the court has jurisdiction in this particular case, I do not join the court in part 2 of its opinion, in fashioning a new presumption of jurisdiction over cases coming here from state courts. Although I agree with the court that uniformity in federal criminal law is desirable, I see little efficiency and an increased danger of advisory opinions in the court's new approach. Justice Brennan, with whom Justice Marshall joins, dissenting. The court today holds that the protective search of the passenger compartment of the automobile involved in this case was reasonable under the principles articulated in Terry and other decisions of this court. I disagree. Terry v. Ohio does not support the court's conclusion, and the reliance on other decisions is patently misplaced. Plainly, the court is simply continuing the process of distorting Terry beyond recognition and forcing it into service as an unlikely weapon against the Fourth Amendment's fundamental requirement that searches and seizures be based on probable cause. I therefore dissent. On 3 occasions this term, I have discussed the limited scope of the expectation to the probable cause requirement created by Terry and his progeny. See Florida v. Royer, Collender v. Lawson, United States v. Place. I will not repeat those discussions here, and note only that Terry and the cases that followed it permit only brief investigative stops and extremely limited searches based on reasonable suspicion. However, the court's opinion compels a detailed view of Terry itself. In Terry, the court confronted the quite narrow question of whether it is always unreasonable for a policeman to seize a person and subject him to a limited search for weapons unless there is probable cause for an arrest. Because the court was dealing with an entire rubric of police conduct, which historically had not been, and, as a practical matter could not be, subjected to the warrant procedure, the court tested the conduct at issue by the Fourth Amendment's general prescription against unreasonable searches and seizures. In considering the reasonableness of the conduct, the court balanced the need to search or seize against the invasion which the search or seizure entails. It deserves emphasis that in discussing the invasion at issue, the court stated that even a limited search of the outer clothing for weapons constitutes a severe, though brief, intrusion upon cherished personal security. Ultimately, the court concluded that there must be a narrowly drawn authority to permit a reasonable search for weapons for the protection of the police officer, where he has reason to believe that he is dealing with an armed and dangerous individual, regardless of whether he has probable cause to arrest the individual for a crime. The court expressed its holding as follows. We merely hold today that where a police officer observes unusual conduct, which leads him reasonably to conclude in light of his experience that criminal activity may be afoot, and that the persons with whom he is dealing may be armed and presently dangerous, where in the course of investigating this behavior he identifies himself as a policeman and makes reasonable inquiries, and where nothing in the initial stages of the encounter serves to dispel his reasonable fear for his own or others' safety, he is entitled for the protection of himself and others in the area to conduct a carefully limited search of the outer clothing of such persons in an attempt to discover weapons which might be used to assault him. It is clear that Terry authorized only limited searches of the person for weapons. In light of what Terry said, relevant portions of which the court neglects to quote, the court's suggestion that Terry need not be read as restricting the preventative search to the person of the detained suspect can only be prescribed as disingenuous. Nothing in Terry authorized police officers to search a suspect's car based on reasonable suspicion. The court confirmed this very term in United States v. Place, where it described the search authorized by Terry as a limited search for weapons or frisk. The search at issue in this case is a far cry from a frisk, and certainly was not limited. The court's reliance on Chimel v. California and New York v. Belton as support for its new area search rule within the context of a Terry stop is misplaced. In Chimel, the court addressed the scope of a search incident to a lawful arrest, and held invalid the search at issue there because it went far beyond the petitioner's person and the area from within which he might have obtained either a weapon or something that could have been used as evidence against him. Chimel stressed the need to limit the scope of searches incident to arrest and overruled 2 prior decisions of this court validating overly broad searches. In Belton, the court considered the scope of a search incident to the lawful custodial arrest of an occupant of an automobile. In this particular and problematic context, the court held that when a policeman has made a lawful custodial arrest of the occupant of an automobile, he may, as a contemporaneous incident of that arrest, search the passenger compartment of that automobile. The critical distinction between this case and Terry, on the one hand, and Schimmel and Belton on the other, is that the latter two cases arose within the context of lawful custodial arrests supported by probable cause. The court in Terry expressly recognized the difference between a search incident to arrest and the limited search for weapons involved in that case. The court stated, "A search incident to arrest, although justified in part by the acknowledged necessity to protect the arresting officer from assault with a concealed weapon, is also justified on other grounds, and can therefore involve a relatively extensive exploration of the person. A search for weapons in the absence of probable cause to arrest, however, must, like any other search, be strictly circumscribed by the exigencies which justify its initiation. Thus, it must be limited to that which is necessary for the discovery of weapons which might be used to harm the officer or others nearby, and may realistically be characterized as something less than a full search, even though it remains a serious intrusion." An arrest is a wholly different kind of intrusion upon individual freedom from a limited search for weapons, and the interests each is designed to serve are likewise quite different. An arrest is the initial stage of a criminal prosecution. It is intended to vindicate society's interest in having its laws obeyed, and it is inevitably accompanied by future interference with the individual's freedom of movement, whether or not trial or conviction ultimately follows. The protective search for weapons, on the other hand, constitutes a brief, though far from inconsiderable, intrusion upon the sanctity of the person. In United States v. Robinson, the court relied on the differences between searches incident to lawful custodial arrests and Terry stop and frisk searches to reject an argument that the limitations established in Terry should be applied to a search incident to arrest. The court noted that Terry clearly recognized the distinction between the two types of searches, and that a different rule governed one than governed the other, and described Terry as involving stricter standards than those governing searches incident to arrest. The court went on to state, "A custodial arrest of a suspect based on probable cause is a reasonable intrusion under the Fourth Amendment. That intrusion being lawful, a search incident to the arrest requires no additional justification. It is the fact of the lawful arrest which establishes the authority to search, and we hold that in the case of a lawful custodial arrest, a full search of the person is not only an exception to the warrant requirement of the Fourth Amendment, but is also a reasonable search under that amendment." See also Gustafson v. Florida. The search incident to arrest is reasonable under the Fourth Amendment because the privacy interest protected by that constitutional guarantee is legitimately abated by the fact of the arrest. As these cases recognize, there is a vital difference between searches incident to lawful custodial arrests and Terry protective searches. The court deliberately ignores that difference in relying on principles developed within the context of intrusion supported by probable cause to arrest to construct an area search rule within the context of a Terry stop. The court denies that an area search is fundamentally inconsistent with Terry, stating, "We have recognized that Terry searches are limited insofar as they may not be conducted in the absence of an articulable suspicion that the intrusion is justified, and that they are protective in nature and limited to weapons. However, neither of these concerns is violated by our decision. To engage in an area search, which is limited to seeking weapons, the officer must have an articulable suspicion that the suspect is potentially dangerous." This patently is no answer. Respondent's argument relates to the scope of the search, not to the standard that justifies it. The court flouts Terry's holding that Terry searches must be carefully limited in scope. Indeed, the Page and Sibrin v. New York, cited by the court, states, even assuming, arguendo, that there were adequate grounds to search Sibrin for weapons, the nature and scope of the search conducted by Patrolman Martin were so clearly unrelated to that justification as to render the heroin inadmissible. The search for weapons approved in Terry consisted solely of a limited patting of the outer clothing of the suspect for concealed objects which might be used as instruments of assault. Only when he discovered such objects did the officer in Terry place his hands in the pockets of the men he searched. In this case, with no attempt at an initial limited exploration for arms, Patrolman Martin thrust his hand into Sibrin's pocket and took from him envelopes of heroin. His testimony shows that he was looking for narcotics and he found them. The search was not reasonably limited in scope to the accomplishment of the only goal which might conceivably have justified its inception: the protection of the officer by disarming a potentially dangerous man. As this passage makes clear, the scope of a search is determined not only by reference to its purpose, but also by reference to its intrusiveness. Yet the court today holds that a search of a car and the containers within it, that is not even occupied by the suspect, is only as intrusive as, or perhaps less intrusive than, thrusting a hand into a pocket after an initial pat-down has suggested the presence of concealed objects that might be used as weapons. The court suggests no limit on the area search it now authorizes. The court states that a search of the passenger compartment of an automobile, limited to those areas in which a weapon may be placed or hidden, is permissible if the police officer possesses a reasonable belief based on specific and articulable facts, which taken together with the rational inferences from those facts, reasonably warrant the officers in believing that the suspect is dangerous, and the suspect may gain immediate control of weapons. Presumably, a weapon may be placed or hidden anywhere in a car. A weapon might also be hidden in a container in the car. In this case, the court upholds the officer's search of a leather pouch because it could have contained a weapon. In addition, the court's requirement that an officer have a reasonable suspicion that a suspect is armed and dangerous does little to check the initiation of an area search. In this case, the officer saw a hunting knife in the car, but the court does not base its holding that the subsequent search was permissible on the ground that possession of the knife may have been illegal under state law. An individual can lawfully possess many things that can be used as weapons. A hammer or a baseball bat can be used as a very effective weapon. Finally, the court relies on the following facts to conclude that the officers had a reasonable suspicion that respondent was presently dangerous. The hour was late, the area was rural, respondent had been driving at an excessive speed, he had been involved in an accident, he was not immediately responsive to the officer's questions, and he appeared to be under the influence of some intoxicant. Based on these facts, one might reasonably conclude that the respondent was drunk. A drunken driver is indeed dangerous while driving, but not while stopped on the roadside by the police. Even when an intoxicated person lawfully has in his car an object that could be used as a weapon, it requires imagination to conclude that he is presently dangerous. Even assuming that the facts in this case justify the officer's initial frisk of respondent, they hardly provide adequate justification for a search of a suspect's car and the containers within it. This represents an intrusion, not just different in degree, but in kind, from the intrusion sanctioned by Terry. In short, the implications of the court's decision are frightening. The court also rejects the Michigan Supreme Court's view that it was not reasonable for the officers to fear that respondent could injure them because he was effectively under their control during the investigative stop and could not get access to any weapons that might have been located in the automobile. In this regard, the court states, "We stress that a Terry investigation, such as the one that occurred here, involves a police investigation at close range. When the officer remains particularly vulnerable in part because a full custodial arrest has not been effected, and the officer must make a quick decision as to how to protect himself and others from possible danger. In such circumstances, we have not required that officers adopt alternative means to ensure their safety in order to avoid the intrusion involved in a Terry encounter." See Ibid. and as such might suggest the need for resort to alternative means, the court's reasoning is perverse. The court's argument, in essence, is that the absence of probable cause to arrest compels the conclusion that a broad search, traditionally associated in scope with a search incident to arrest, must be permitted based on reasonable suspicion. But United States v. Robinson stated, "It is scarcely open to doubt that the danger to an officer is far greater in the case of the extended exposure which follows the taking of a suspect into custody and transporting him to the police station than in the case of the relatively fleeting contact resulting from the typical Terry-type stop." In light of Robinson's observation, today's holding leaves in grave doubt the question of whether the court's assessment of the relative dangers posed by given confrontations is based on any principled standard. Moreover, the court's reliance on a balancing of the relevant interests to justify its decision is certainly inappropriate. In Dunaway v. New York, the court stated that the narrow intrusions involved in Terry and its progeny were judged by a balancing test rather than by the general principle that Fourth Amendment seizures must be supported by the long-prevailed standards of probable cause, only because these intrusions fell far short of the kind of intrusion associated with an arrest. The intrusion involved in this case is precisely the kind of intrusion associated with an arrest. There is no justification, therefore, for balancing the relevant interests. In sum, today's decision reflects, once again, the threat to Fourth Amendment values posed by balancing. To say that the search must be reasonable is to require some criterion of reason. It is no guide at all, either for a jury or for district judges or the police, to say that an unreasonable search is forbidden, that the search must be reasonable. What is the test of reason which makes a search reasonable? The test is the reason underlying and expressed by the Fourth Amendment, the history and the experience which it embodies, and the safeguards afforded by it against the evils to which it was a response. Hornbook law has been that the police may not conduct a search unless they first convince a neutral magistrate that there is probable cause to do so. While under some circumstances the police may search a car without a warrant, the exception to the warrant requirement established in Carroll applies only to searches of vehicles that are supported by probable cause. The court in Carroll emphasized the importance of the requirement that officers have probable cause to believe that the vehicle contains contraband. Today, the court discards these basic principles and employs the very narrow exception established by Terry, to swallow the general rule that Fourth Amendment searches of cars are reasonable only if based on probable cause. Today's decision disregards the court's warning in Almeida Sanchez. The needs of law enforcement stand in constant tension with the Constitution's protections of the individual against certain exercises of official power. It is precisely the predictability of these pressures that counsels a resolute loyalty to constitutional safeguards. Of course, police should not be exposed to unnecessary danger in the performance of their duties. But a search of a car and the containers within it, based on nothing more than a reasonable suspicion, even under the circumstances present here, cannot be sustained without doing violence to the requirements of the Fourth Amendment. There is no reason in this case why the officers could not have pursued less intrusive but equally effective means of ensuring their safety. The court takes a long step today towards balancing into oblivion the protections the Fourth Amendment affords. I dissent, for as Justice Jackson said in Brinegar v. United States, Fourth Amendment rights are not mere second-class rights, but belong in the catalog of indispensable freedom. Among deprivations of rights, none is so effective in cowing a population, crushing the spirit of the individual, and putting terror in every heart. Uncontrolled search and seizure is one of the first and most effective weapons in the arsenal of every arbitrary government. Justice Stevens, dissenting. The jurisprudential questions presented in this case are far more important than the question whether the Michigan police officer's search of respondent's car violated the Fourth Amendment. The case raises profoundly significant questions concerning the relationship between two sovereigns, the state of Michigan and the United States of America. The Supreme Court of the state of Michigan expressly held that the deputy's search of the vehicle was prescribed by the Fourth Amendment to the United States Constitution and Article 1, Section 11 of the Michigan Constitution. The state law ground is clearly adequate to support the judgment, but the question whether it is independent of the Michigan Supreme Court's understanding of federal law is more difficult. Four possible ways of resolving that question present themselves. 1. Asking the Michigan Supreme Court directly. 2. Attempting to infer from all probable sources of state law what the Michigan Supreme Court meant. 3. Presuming that adequate state grounds are independent unless it clearly appears otherwise. Or 4. Presuming that adequate state grounds are not independent unless it clearly appears otherwise. This court has, on different occasions, employed each of the first three approaches. Never until today has it even hinted at the fourth. In order to achieve the consistency that is necessary, the court today undertakes a re-examination of all the possibilities. It rejects the first approach as inefficient and unduly burdensome for state courts, and rejects the second approach as an inappropriate expenditure of our resources. Although I find both of those decisions defensible in themselves, I cannot accept the court's decision to choose the fourth approach over the third, to presume that adequate state grounds are intended to be dependent on federal law unless the record plainly shows otherwise. I must therefore dissent. If we reject the intermediate approaches, we are left with a choice between two presumptions, one in favor of our taking jurisdiction and one against it. Historically, the latter presumption has always prevailed. The rule, as succinctly stated in Lynch, was as follows. Where the judgment of the state court rests on two grounds, one involving a federal question and the other not, or it does not appear upon which of the two grounds the judgment was based, and the ground independent of a federal question is sufficient in itself to sustain it, this court will not take jurisdiction. The court today points out that in several cases we have weakened the traditional presumption by using the other two intermediate approaches identified above. Since those two approaches are now to be rejected, however, I would think that stare decisis would call for a return to historical principle. Instead, the court seems to conclude that because some precedents are to be rejected, we must overrule them all. Even if I agree with the court that we are free to consider, as a fresh proposition, whether we may take presumptive jurisdiction over the decisions of sovereign states, I could not agree that an expansive attitude makes good sense. It appears to be common ground that any rule we adopt should show respect for state courts and a desire to avoid advice. And I am confident that all members of this court agree that there is a vital interest in the sound management of scarce federal judicial resources, and all of those policies counsel against the exercise of federal jurisdiction. They are fortified by my belief that a policy of judicial restraint, one that allows for other decisional bodies to have the last word in legal interpretation until it is fully necessary for this court to intervene, enables the court to make its most effective contribution to our federal system of government. The nature of the case before us hardly compels a departure from tradition. These are not cases in which an American citizen has been deprived of a right secured by the United States Constitution or a federal statute. Rather, they are cases in which a state court has upheld a citizen's assertion of a right, finding the citizen to be protected under both federal and state law. The attorney for the complaining party is an officer of the state itself, who asks us to rule that the state court interpreted federal rights too broadly and overprotected the citizen. Such cases should not be of inherent concern to this court. The reason may be illuminated by assuming that the events underlying this case had arisen in another country, perhaps the Republic of Finland. If the Finnish police had arrested a Finnish citizen for possession of marijuana, and the Finnish courts had turned him loose, no American would have standing to object. If instead they had arrested an American citizen and acquitted him, we might have been concerned about the arrest, but we surely could not have complained about the acquittal, even if the Finnish court had based its decision on its understanding of the United States Constitution. That would be true even if we had a treaty with Finland requiring it to respect the rights of American citizens under the United States Constitution. We would only be motivated to intervene if an American citizen were unfairly arrested, tried, and convicted by the foreign tribunal. In this case, the state of Michigan has arrested one of its citizens, and the Michigan Supreme Court has decided to turn him loose. The respondent is a United States citizen as well as a Michigan citizen, but since there is no claim that he has been mistreated by the state of Michigan, the final outcome of the state processes offended no federal interest whatsoever. Michigan simply provided greater protection to one of its citizens than some other state might provide, or, indeed, that this court might require throughout the country. I believe that in reviewing the decisions of state courts, the primary role of this court is to make sure that persons who seek to vindicate federal rights have been fairly heard. That belief resonates with statements in many of our prior cases. In Abbey State Bank v. Bryan, the Supreme Court of Nebraska had rejected a federal constitutional claim relying in part on the state law doctrine of laches. Writing for the court in response to the Nebraska governor's argument that the court should not accept jurisdiction because laches provided an independent ground for decision, Chief Justice Hughes concluded that this court must ascertain for itself whether the asserted non-federal ground independently and adequately supported the judgment, in order that constitutional guarantees may appropriately be enforced. He relied on our earlier opinion in Union Pacific Railroad Company v. Public Service Commission of Missouri, in which Justice Holmes had made it clear that the court engaged in such an inquiry so that it would not be possible for a state to impose an unconstitutional burden on a private party. And both Abbey and Union Pacific rely on Creswell v. Knights of Pythias, in which the court explained its duty to review the findings of fact of a state court where a federal right has been denied. Until recently, we had virtually no interest in cases of this type. 30 years ago, this court reviewed only one, Nevada v. Stacher. Indeed, that appears to have been the only case during the entire 1953 term in which a state even sought review of a decision by its own judiciary. 15 years ago, we did not review any such cases, although the total number of requests had mounted to 3. Sometime during the past decade, perhaps about the time of the 5-4 decision in Zacchini v. Scripps Howard Broadcasting Company, our priorities shifted. The result is a docket swollen with requests by states to reverse judgments that their courts have rendered in favor of their citizens. I'm confident that a future court will recognize the error of this allocation of resources. When that day comes, I think it likely that the court will also reconsider the propriety of today's expansion of our jurisdiction. The court offers only one reason for asserting authority over cases such as the one presented today: an important need for uniformity in federal law that goes unsatisfied when we fail to review an opinion that rests primarily upon federal grounds and where the independence of an alleged state ground is not apparent from the four corners of the opinion. Ante at 1040. Of course, the supposed need to review an opinion clashes directly with our oft-repeated reminder that our power is to correct wrong judgments, not to revise opinions. The clash is not merely one of form. The need for uniformity in federal law is truly an ungovernable engine. That same need is no less present when it is perfectly clear that a state ground is both independent and adequate. In fact, it is equally present if a state prosecutor announces that he believes a certain policy of non-enforcement is commanded by federal law, yet we have never claimed jurisdiction to correct such errors, no matter how egregious they may be, and no matter how much they may thwart the desires of the state electorate. We do not sit to expound our understanding of the Constitution to interested listeners in the legal community. We sit to resolve disputes. If it is not apparent that our views would affect the outcome of a particular case, we cannot presume to interfere. Finally, I am thoroughly baffled by the court's suggestion that it must stretch its jurisdiction and reverse the judgment of the Michigan Supreme Court in order to show respect for the independence of state courts. Would we show respect for the Republic of Finland by convening a special sitting for the sole purpose of declaring that its decision to release an American citizen was based upon a misunderstanding of American law? I respectfully dissent. For more audio cases, visit us at laudioforlisteners.com. Follow us on Instagram and Facebook, and subscribe to our YouTube channel.